Well, we are in the middle of jury selection for the second time in the YNW Melly murder case, and there are still being a bevy of motions that are being filed, and they have to have hearings for all these motions, so this is still going to be a little while before the actual trial starts. And one of the motions we're going to discuss today, but before we discuss the motion, I want to discuss a little bit about the hearing that went on today. Now, there's been some comments before, just so you know, side point, there's been some comments about how I talk too fast. So I'm going to try to talk a little bit slower in this video. If you don't like the slow, if you like it faster, if you like it slower, please let me know in the comments so I can tailor these videos for you, my beloved subscribers and viewers. So let's jump into the hearing. Now, the problem with the hearing is that the audio was really not good and it was very, very difficult to make out what was being said. We do know that Michelle Buttress took the stand. We do know that Detective Moretti took the stand, and it was just difficult to make out what they were saying, at least in the recordings that I heard. If anybody has a better recording or a website that has a better recording, please let me know in the comments. I would love to hear the hearing beginning to end, and then obviously I can bring you a lot better analysis about what exactly happened and what the legal ramifications and implications could be from the hearing today. But from what I did glean and from certain filings, I was able to figure out a few things. So this is what I was able to figure out. Number one is that there's some filings by the state in this case, which were what they call supplemental discovery. And this is where they're essentially just telling us some of the bullet points. They're telling the court, really, and we're just looking at it because it's public record. They're telling the court some of the bullet points of the discovery that they're turning over to the defense in this case. And so therefore, whatever I'm going to be discussing with you, I can't show you the actual text messages or show you the actual emails or the videos or the audio and some of the exhibits that they're talking about in the filings, but I will tell you the bullet points, and either you can trust the state or not trust the state for what it actually says. So the first thing, which was interesting, and I think it's important, is that we have to remember again, what was Michelle Buttress's testimony here? Michelle Buttress, there's two main points I want to discuss today, which was part of her testimony. Obviously, the main part was that she heard Detective Moretti solicit Deputy Gorell to lie for him and say that he was in the room when he was not in the room. And the reason for that is that Detective Moretti does not have jurisdiction in the place where he was taking this statement by Ms. King. Remember that Michelle Buttress was the prosecuting attorney. She's been doing this for 20 years. She was investigating jury tampering claims against Melly and Melly's mother, Ms. King. And during that process, she took a statement by Ms. King. And while she was taking the statement, Detective Moretti was in the room, and there was a deputy in the room, but the deputy left. And then when the deputy left, Detective Moretti served a search warrant on Ms. King for her phone. And there was no deputy present. And then when the deputy came back into the room later, Detective Moretti, this is what Michelle Buttress' testimony was, that Detective Moretti asked Deputy Gorell to lie for him and say that he was in the room. And that's what Michelle Buttress' testimony was. And then her testimony was that she was so turned off by that conduct, by the conduct of Detective Moretti soliciting a deputy to lie for him, that she just, after that, wanted to have nothing to do with Detective Moretti. She didn't want to have anything to do with this investigation anymore. She just wanted to be done with it, and she has no respect anymore for Detective Moretti. Essentially, that's what she said. So those 2 points are what we're going to discuss. So now we have Detective Moretti on the stand. But there's this memo. There's this memo that was written because there was a complaint that was filed by Ms. King's attorney for the conduct that occurred in that interrogation room, if you want to call it that. In that room where she was giving a statement, there was some conduct in which Detective Moretti grabbed Ms. King's phone out of her hands. And because of the conduct, Ms. King's attorney filed a complaint. And there was a Sergeant Brittany Parker who was assigned to investigate this complaint. And she wrote a memo, and in that memo, that's where she's closing out the complaint, where she's basically saying there's no basis, we're not going to continue investigating this complaint. There's no basis for this complaint to be made, essentially. Now, in that memo, she says that Michelle Buttress's sworn statement is inconsistent with the audio recording due to the fact that she told Sergeant Parker that she did not see Ms. King attempt to turn off her phone. So remember, what happened here was that after Detective Moretti served the search warrant on Ms. King right away tried to shut off her phone. And there's been some audio that says that you can hear where Michelle Buttress is telling Ms. King that she has to hand her phone over. And even though she's insisting that she has to, Miss Michelle Buttress is insisting that Ms. King has to turn over her phone, she refuses to do so. But in her statement, in Michelle Buttress's statement to Sergeant Parker, in her sworn statement, is what Sergeant Parker refers to it as, Michelle Buttress says that she did not see Ms. King attempt to turn off her phone. So she's saying that's inconsistent. There's inconsistency with Michelle Buttress's sworn statement and the audio. So how much can we really trust Michelle Buttress at this point? That's what the suggestion that Sergeant Parker is making. Number two, she says, and there's a bunch of different bullet points. I'm not going to go through all of them, but another important bullet point from this memo by Sergeant Brittany Parker was that Deputy Gorell's sworn statement and sworn police report refute the accusation that Detective Moretti asked Deputy Gorell to declare he was present during the execution of the search warrant, which means that Deputy Gorell has a sworn statement. He wrote a sworn statement or gave a sworn statement and a sworn police report that Detective Moretti never asked him to lie. So that also refutes Michelle Buttress's testimony that in fact, Detective Moretti did ask him to lie. So because of these refutations, now, how is Sergeant Parker supposed to believe? How is she supposed to choose who to believe? Well, apparently, in this memo, she decided to believe Deputy Gorell. And perhaps part of the reason is that she already saw, or she concluded herself, that Michelle Buttress was not being honest because there's already inconsistency with what Michelle Buttress told Sergeant Parker and what Sergeant Parker heard on the audio. So maybe that's what painted Michelle Buttress in not such a great light, and that's why Sergeant Parker decided, we're not going to listen to Michelle Buttress, we're going to side with Deputy Gorell, and therefore we're closing out the complaint. There's nothing to investigate anything further. So that's one part. Now, Detective Moretti also, and I'm assuming this is what he did on the stand, although I couldn't hear it clearly. But in this discovery, which the state is turning over, Detective Moretti stated that there was no BSO deputy present during the seizure of Ms. King's phone. Meaning Detective Moretti is acknowledging, he's admitting that there was no deputy present when he served that search warrant on Ms. King. Now you may stop for a second and tell yourself, well, hold on a second. Detective Moretti is really opening a big can of worms, and so is the state. If the state is now going to make the case, and I'm assuming this is what Detective Moretti said on the stand as well, that there was no deputy in the room, and he never asked Deputy Gorell to lie for him. Well, if that's the case, don't you have a real serious problem? Because remember, you have to have jurisdiction in order to serve a search warrant. That's the understanding here. And if you don't have jurisdiction to serve that search warrant, well then that search warrant is invalid, and that means that you did something illegal. So how is Detective Moretti going to save himself by saying, I never asked him to lie for me, and he wasn't in the room? Well, if he wasn't in the room, what are you doing serving that search warrant? Don't you know the laws? Don't you know what you're allowed to do and what you're not allowed to do? You're a detective for how many years? And you don't know that you have to have jurisdiction before you serve a search warrant? Well, the reason why that's not going to be a problem is because of another filing. I mean, this is the argument that's going to be made, that there's another filing that the state filed, which also has to do with discovery, and it gives again different bullet points. And remember that Michelle Buttress's testimony was that she was so turned off by Detective Moretti's conduct that she wanted to have nothing to do with him after that incident where he asked the deputy to lie for him. Yet, the state files that there's text messages between, guess who? Detective Moretti and Michelle Buttress after the incident. There's text messages back and forth. And these are days after the incident. Now, there's some text messages before the incident also, which we're going to get to in a minute, but there's text messages a few days after the incident, 5 days after the incident, 2 days after the incident. So they're continuing to be in contact. They're continuing to work on this case together. So how can Michelle Buttress get up there and say, oh, I was so turned off, I wanted to have nothing to do with this case. I don't want to even see Detective Moretti anymore. I don't want to talk to him anymore. I don't want to have anything to do with him. But yet you're texting him. You're having text messages with him about this case. And you're not saying, you're not ignoring him. You're not saying, I don't want to talk to you. You're not doing anything. Your text messages seem like you're talking normally. So that's another point that the state is bringing up. Now here's another interesting point. And this is regarding some text messages that Michelle Buttress had with Detective Moretti. And again, I don't have the exact text message. I'm just telling you what the state says it says. So whether you believe the state or not, that's your choice. But I'm just telling you what the filing with the court that the state is saying these text messages say. And in those text messages, it says that Michelle Buttress actually sent Detective Moretti case law on the ability to serve a search warrant even if it is outside your jurisdiction. That it's permissible. It's actually permissible. I guess under certain circumstances, it's permissible to serve a search warrant even if you're not in jurisdiction. And even if you don't have a deputy there. So you have this text message, essentially, which Michelle Buttress, who's this assistant prosecutor for so many years, who's telling Detective Moretti they've got some case law that says that you're allowed to do this. You are allowed to serve the search warrant even though there's no deputy in the room. Now, if Detective Moretti knew that, why would he ask Deputy Gurrell to lie for him? So that is going to be a great, very strong point, if this text message exists, that Detective Moretti he didn't ask Deputy Gurrell to lie for him, and he didn't feel that he needs to because he was told by Michelle Buttress that he is allowed to serve the search warrant, even though it's out of his jurisdiction. So those are some of the interesting things that came out. Again, if you do have some sort of audio of that hearing that is better than the ones that I was able to get online, please let me know in the comments so I can go listen to them. So that takes us to one of the motions in limine, which I thought was a very interesting motion in limine, and we have an order that was filed also today. I believe this is filed today or recently. So one of the motions in limine was regarding, this is a motion in limine that the defense filed. What is a motion in limine? A motion in limine is simply where you as an attorney don't want certain evidence to come in during the trial. And you have to have a basis, obviously, everything that you ask for, you have to have a basis in the law why this evidence is not allowed to come in. So you ask the judge, it's called a motion in limine, which you're asking the judge, do not allow this evidence to come into trial. So the state filed, the defense, Melly's defense, Jamel Dumm's defense, they filed a motion in limine to not allow the agreements or evidence of agreements between Demmons and Williams as to sharing of any money. That's what they titled it. Motion in limine agreement between Demmons and Williams as to sharing of any money. And this is what they argue. The defense believes that the state will argue and attempt to present witnesses that there was an agreement between Jamel Demmons and Anthony Williams to share or split all of the money that Mr. Demmons made through his musical pursuits. So the defense assumes that this is what the state is going to bring out. The state's going to bring out that either through witnesses or other evidence that there was an agreement between Jamel Demmons and Anthony Williams to share or split some of the money. Unless the state can present a signed contract or agreement or a verbal acknowledgement by Mr. Demmons that he owed that money to Mr. Williams, or correspondence by Mr. Demmons that he owed Mr. Williams this money, any reference to it would be pure hearsay and conjecture. You don't have a contract, you don't have a verbal acknowledgement, you don't have any correspondence between Mr. Demmons and Mr. Williams about this money, then any talking points that you want to bring out, any arguments that you want to bring out about this alleged money and the alleged split of the money, and that's why Melly wanted to murder Anthony Williams, it's all based on conjecture and hearsay, and therefore you're not allowed to argue it during your opening statements. You're not allowed to say that that's what the evidence is going to show. And you're not allowed to argument, obviously, in closing arguments either. You're not allowed to make this an issue at all because you have no basis other than conjecture, and hearsay that there was any sort of deal at all. There's no evidence of any deal, any agreement between Anthony Williams and Jamel Demmons. So you can't argue that. You can't argue this. Now, The reason why this is very important, as we discussed in other videos, is that the death penalty is on the table here. And we know that one of the aggravating factors that the jury can take into account when deciding whether, if there is a conviction for the first-degree murder charge here, if there's a conviction, whether they can take certain factors into consideration when deciding whether to give the death penalty or not. Some of the aggravating factors, one of the aggravating factors is pecuniary gain. If there's some pecuniary gain, if there's some financial gain that Melly could have had by murdering Anthony Williams, then that could be an aggravating factor that the jury can use to impose the death penalty in this case. So therefore, the defense doesn't want any of this in. They want it all out, because then it's just one less aggravating factor that the jury can take into account. And obviously the state wants this in. So what's the state's response? So the state responded that this is what they argued. This is what they argued. They argue the following. Defense contends that the state must present a signed contract or agreement, a verbal acknowledgement from the defendant, or correspondence from Demons that he owed Williams money. That was essentially the defense's position. However, says the state, however, it would be inaccurate to say that these are the only means that the state may present evidence of pecuniary gain. Says this, so the state's argument that it's not the only evidence. You're right, a signed contract would be great evidence. A signed agreement would be great evidence. A verbal acknowledgement would be a great evidence. Correspondence would certainly be great evidence. But guess what? We're not limited to what you say we're limited in. There can be other evidence of pecuniary gain. For example, the state continues. As previously noted, the state has provided by financial records as well as communications between the victim Williams and defendant Demons, as well as other messages from Demons that make a prima facie showing that finances were at least one aspect of an ongoing conflict between Demons and Williams. We are going to show, the state's saying, we're going to show evidence that there was a conflict. There was the point of contention between Demons and Williams was money. Finances was a point of contention. And you're going to see that in the text messages. Chief among them are messages from Williams proclaiming himself CEO of YNW. Meanwhile, Demons was the clear moneymaker of the group. So Demons here is making all the money, and here we have Williams proclaiming himself as CEO of YNW, and that's what some of the messages are going to show. The defendant stood to make $16 million based upon his work and was going to have to divide it among those who did not contribute as much, including a self-proclaimed leader. So you got Williams self-proclaiming himself as the CEO of YNW. There's no document saying that he's a CEO. And there he is self-proclaiming himself as CEO. That is enough evidence to show that the reason why, the motive behind Demons, behind Melly murdering, allegedly, Williams is for financial gain. And therefore, it is admissible. Now, even though motive is not necessary for the state to prove, still they bring some case law that evidence of motive is still allowed in. It's still allowed in. So this evidence is still allowed in, just to prove motive. But that's essentially what it comes down to. The question that comes down to, do you need a verbal acknowledgement? Do you need a contract? Do you need some sort of correspondence? Or is there enough of this other evidence, which is not as direct as a contract? Is there enough evidence by these text messages, seeing that money is a point of contention, that could lead the jury to believe that the motive behind this was for pecuniary gain, and therefore they can consider that in deciding that the death penalty for Melly. So the judge filed an order in this case, and he wrote an opinion, small opinion. Now you would think that what the judge should do here is say, yeah, I side with the defense in this case, that just showing some text messages is not enough. Or he should say, or you would think that he would say, that the prosecution is right, that they don't need to produce a signed contract. They don't need to produce a verbal, have a verbal acknowledgement, some sort of recording, or to produce some sort of emails showing that there's a clear understanding of a certain split here. And it's enough for them to just show these other text messages that saying that Williams is a CEO. You would think that that's what he would conclude here. However, he doesn't do that. what he does do is the following. This is what he says in his order. Now, he says he's denying the defendant's motion. So he's definitely denying the defendant's motion in limine, which means that this evidence is going to come in. But this is what he says. The court finds that the state can make references in their opening statement to any evidence if it has a good faith belief that the evidence will be admitted at trial. So this is a very generic and general statement that, yeah, during opening statements, you're only allowed to talk about evidence which you believe will be admitted at trial. As long as the evidence is probative, it is up to the jury to decide what weight to give it and what inferences to draw from it. So it's up to the jury. The jury can decide what these text messages mean. The jury can decide whether there's some point of contention with money. They're able to decide that on their own. The court has no doubt. Now, this is what interesting line that the judge throws in here. The court has no doubt that the state is aware of its ethical duties as well as the potential consequences of referencing evidence in their opening statement that will not be introduced at trial. Meaning, the state should understand the potential consequences of referencing evidence in their opening statement that will not be introduced at trial, which is really doesn't seem like it has a place here. This is where, if you want to talk about evidence that you know doesn't exist. So can you talk to the jury, and can the state say to the jury in their opening statements, you're going to see evidence of a video showing Melly pulling the trigger? Of course they can't do that because there's no evidence of that. So if they know there's no evidence of that and there's not even good faith that that evidence is going to come in, of course they can't do that. That's not the question here. The question here is that the state is going to say during their opening statements that there's evidence of these financial issues that they had. And they're going to be referring to those text messages. That's not the question here, which is why it's just a little interesting that the judge is kind of going in this direction here. You would think that the judge, like I said, was just going to say, the state is right, that these text messages is good enough, and the jury can decide whatever it wants from it. But he doesn't specifically say that. And sometimes judges do that. They kind of punt on the main issue, and they kind of rule in one way, which allows the evidence to come in without giving a clear ruling about this specific issue. Okay, well, that is what happened. So this evidence is going to come in, and therefore the evidence of pecuniary gain is on the table and will eventually, well, of course, will be argued by the state in their opening, in their closing, and if there's a conviction, the jury will be able to weigh that in on one of the aggravating factors, whether Melly should deserve the death penalty. Okay, that's it for now. If you haven't yet, please subscribe, like the video so we can continue growing. Thanks again. That's it for now.